I'm Matt Gishard, and this is No Holds Barred. In today's episode, we're going to talk about common real estate law issues. I'm pleased to have with me Randall Davis, a partner in the Walnut Creek law firm of Israel and Samuels, real estate attorneys. Well, let's assume you've gone through all that process. Somebody's found a, let's assume they're a buyer. They've found a piece of property, gone through the contract, everything, deal's done. They start to occupy the residence and they find out, there are cracks in the floor, or the cracks in the back patio, or there's slippage in the hill behind, all the various things that can happen. So what does a person do in that situation?
Well, the first thing is you need to know your rights. Depending on the situation, it may be a patent or latent defect in real property, and there are different statute of limitations for bringing an action for those.
Well, tell us, before I interrupt you, and while
Sure.
I interrupt you, is what's patent and latent for our audience?
Well, patent is obvious. I walk in, I see it, I know the cause, the pipe is leaking. That would be a patent defect. A latent defect, it's in the wall. You can't see it. It doesn't. It couldn't have come to your attention with a reasonable inspection. For a patent defect, from the time you discover the facts that lead you to know it's patent, you have 5 years to file a lawsuit. Now, may have less for breach of contract, but you have 5 years for a patent defect in real property. And that would be only against the owner who was the builder. If they weren't the builder, you're only subject to contract, and that's the statute of limitations for written contract. Latent defect, if it was a builder owner, it's 10 years from the certificate of occupancy. So depending on what has happened with the property and who owned it when, you may have longer periods than you would if you were just buying an old house from a third owner. I will say that, to answer your original question, that the most important thing to do is find out what it's going to cost. Because litigation is expensive, and it is anxiety producing, not so much for the attorneys as for their clients. And if it's a small item, it's probably in your best interest just to go get it fixed, even if it means you have to take out a small loan to do so. If it's your property's going down, there's no foundation, and it's a significant issue, then you may want to seek recompense from the seller if they fail to disclose their knowledge that it was occurring. And that's the problem. You've got to prove that.
Yeah, so, obviously, every time we've bought or sold property, and everyone, you hire an inspector, inspectors come in, there's the standard kind of inspection, a termite person, but then there's nowadays, gosh, people come in, they look under every rock in the property. So if you have either a patent or latent defect, you've had inspectors on all sides, and you've occupied the house, you didn't know, you relied on an inspector. Do you have a cause of action against the inspector as well as the seller?
Possibly, but in most of those cases, you've given that right away by contracting with them in the terms and conditions of their contract. That says they are not warranting and they're just telling you what they see and discovered. Which means choosing a home inspector, if possible, that isn't representing a broker who's going to get a commission from the transaction, but a licensed contractor rather than just a home inspector is probably in your best interest.
I see. We had a case at one point where somebody came in, it was an older house, and on the fireplace wall in the living room was this brand new paneling that was put up and kind of didn't match. People were wondering, but occupied the house, went in, didn't like the paneling, pulled it off, and there was a ton of dry rot and stuff in that wall. And clearly it was put up to hide. So no inspector could have seen that and the people wouldn't have known. So under that circumstance, I do know a lawsuit was brought against the seller for purposefully hiding a defect.
Absolutely. If a seller intentionally misrepresents or fails to disclose a known defect, you can sue the seller. The problem with suing the seller is, like everything else in law, do they have money to pay you should you win? Because you're going to spend money going after them as well.
So you could get the potential that the seller sells the house, gets the money for it, invests that money in another house, is living somewhere else, and is cash poor but house rich at the other thing. So,
and if he's living there, he gets an exemption from attachment, so he keeps the amount of debt on the house, whether real or not, at a point where you could not attach and get value on a foreclosure. What's to do his credit? Well, that's not your problem, it's his.
well, let's go back to that arbitration issue. So the arbitration, when you sign that contract, is for whom? Against the seller, against your broker, against the real estate agent, against the other real estate, a number of parties.
Right. Anybody involved with the transaction is signed onto that agreement. It's usually the broker, the salesperson, the seller, and the buyer. And sometimes they have dual agencies, so it's only one real estate broker. They are all subject to that if it's checked and they've all signed it.
I see.
Now, interesting thing is most people use escrow companies for the transfer. And those contracts they sign are put into escrow instructions that an escrow officer carries out. And both parties have a different contract with the escrow holder, who is a fiduciary that doesn't transfer title until all the instructions are completed and loans and monies have exchanged hands.
I see. So going after the title company, so I'll give it another example. We had a case in which the seller of a piece of property, his instructions were selling to certain individuals. That was all agreed to that. And then later the title company changed. They had an LLC, the buyers. So the title company changed on the title document that the sale was to an LLC rather than two individuals. To make a story even longer, the two individuals had personally signed a note to the seller. The LLC had not. So there was a lawsuit, and the title company quickly jumped in and realized they had made a mistake. I think that's unusual. Appointed their own lawyer to correct that for the seller. So in some cases, the title company can even get in trouble in these situations.
I've seen cases most recently where title companies are getting in trouble, where companies have done what's called a Ponzi scheme. It's been around since the 70s or 80s with a guy named Ponzi down in Los Angeles, that basically what you do is you keep selling things and giving the results of your future sales to your prior sales when there's really no money to begin with whatsoever, and then they siphon off a percentage as that goes along, and the last people are left holding the bag. That's basically a Ponzi scheme, and there are a number of nefarious entities out there who are opening up multiple escrows on the same property and then transferring around names and titles and trying to leave title companies holding the bag. So it is a risk they undertake in some cases.
They must be pretty careful if it's a known thing. So what does the title company, what do they do to protect themselves?
Ordinarily, they will request both sides give instructions, and they will not release any funds until they do so. And if they can't agree on an instruction, they will do what's called interplead the money into court and let the parties fight out for the money in court.
I see. So the seller and the buyer each give different instructions to the title company, maybe not significant, but different instructions, and the title company those have to match up.
Right.
Or they're not going to.
Right, with the contract. For example, if somebody says, I want to cancel the escrow, there are consequences to canceling an escrow, usually in the real estate contract. And they cannot close that escrow or cancel it until the parties sign the documents following those cancellation procedures. And if they don't happen, the parties are disputing and arguing, no, you can't cancel, yes, you can't cancel, you can cancel. They will interplead the funds. The court will grant them, the escrow company or title company, their attorney's fees and having to do so or the costs. And they get out of litigation. They say, you guys, figure it out in court. It's not my problem.
So interpleading means take the money that they've received, either from a bank, through a loan or whatever, and interplead it, meaning send it to the court?
Send it to the court. Court deposits it in its accounts, its separate accounts, and the parties go, okay, prove who's entitled to it.
I see.
But it's not mine. I want nothing to do with it. I'm gone.
I see.
And that happens quite often.
So we've talked an awful lot about purchasing property, buying and selling, and kind of the overlay of what you need to do to protect yourself. And interesting whether you check that arbitration box or whether not. Is there also in that contract, purchase contract or sales contract, a mediation provision required prior to an arbitration?
Sure, some of them require that you take your matter to a mediator before you arbitrate. Some say that if you fail to mediate, that you lose the arbitration, or that both sides waive their right to arbitration, you go to court.
Okay. So go to court means you got to file a lawsuit, you got to hire counsel, and you got to go through that process.
Correct. And with the appeals that are possible, with the paying for a jury, if that's who's going to determine the facts of the case. And remember, that jury doesn't want to be there. I love juries, but they don't want to be there. And if there's any reason you can make it that they're not, you are the winner. Because you're rolling dice every time before you go to a bunch of people who don't want to be there.
Well, that's for a discussion for another day about jury selection and jury trials, because understood, many people say, do you want 12 strangers to decide your issue, or do you want to go to a mediation or arbitration and get it done yourself?
You have to take into account the risk that you will lose. And whether you do that after paying me for 1.5 years till you get to trial, or going up front to a mediation and what we call in the industry pay a little tribute to make it go away, you maybe lose if you go to trial, even if you win.
Mm-hmm.
So in some cases, putting it behind you is the best thing you can ever do as soon as possible.
Yeah. Well, that makes sense. We say that in most disputes in civil court. That's what we tell people is best to resolve, settle ahead of time if possible. So
absolutely. In fact, if you think about it, all the provisions in those real estate contracts and escrow contracts and title agreements, they're all to avoid disputes. And then they try to figure a way to handle them if they didn't think of a way a dispute could arise. So the whole idea is to avoid court. Even that contract has that purpose.
Yeah, I can see it's a pretty long contract because we've purchased a house a couple of times over the years. And yeah, sometimes reading it, even as a lawyer, your hair catches on fire trying to read all the provisions and see how that works. Let's jump into something that's a term that many in the audience probably don't know what it means, but we hear it a lot, is a lis pendens. What's a lis pendens and how does that work in the real estate?
That's a fancy Latin phrase that means I'm putting recorded notice of an action pending against you in the chain of title to your property.
All right.
That will affect your ability to refinance and sell until it is released. Once this pendant is filed, you basically can't do either of those because jurisdiction is now with the court over dispute pertaining to the right or title to the property.
So in our purchase, the buyer and the seller they enter the contract, they go through everything. There is a significant dispute. Can one side or the other do a lis pendens on that property? Or let's say the seller sells on their property?
Well, it's usually on the property that is at issue. So an example would be a quiet title action. You have 3 or 4 people saying, "Hey, sold the property to me," and now we got to sort that out. So they'll put a lis pendens on the property, so we can't transfer it, so they get nothing until such time as sorted out.
I see. Well, thanks, Randall. That's interesting. So I think we've kind of covered that general area, not exhaustively, but the general area of just the average person buying and selling, how it kind of works, getting a contract, getting a broker or a real estate agent, and some of the issues that can come up with non-disclosure. For our audience, stay tuned for our next episode of No Holds Barred. We're going to talk some more about common problems in real estate law, and we're going to have Randall Davis discussing those matters with us. If you like this episode, hit the like button, hit the subscribe button. We really appreciate it.